Picture this. You're accused of a crime in the ancient or medieval world. There's no DNA test, no fingerprint kit, no security camera. So how does the court decide if you're guilty? The answer, across dozens of civilizations, was some version of dunk you in water, burn you with hot iron, make you fight a stranger, or feed you poison. And whatever happened next was considered the verdict. And here's the part that should really bother you. This wasn't considered primitive nonsense at the time. It was considered rigorous justice. Let's go through exactly how it worked, because some of it is smarter than you'd think, and some of it is exactly as insane as it sounds. Let's start with medieval Europe, because this is the one most people have vaguely heard of and completely misunderstood. The ordeal of cold water worked like this. The accused was bound and lowered into a pool of water that had been blessed by a priest. The logic, and I want you to sit with how confident this logic was, pure holy water would reject a guilty person, causing them to float. An innocent person would sink because the water accepted them. So to prove your innocence, you had to nearly drown. Someone was standing by to pull you out before you actually died, which, if you think about it, was really the only quality control step in the entire system. The ordeal of hot iron was simpler and, frankly, worse. You'd carry a red-hot iron bar a set number of paces or plunge your hand into boiling water to retrieve a stone. Your hand was then bandaged. 3 days later, a priest inspected the wound. If it was healing cleanly, God had protected you. Innocent. If it was infected, you were guilty. Every burn gets inspected on day 3. Nobody's burn heals in 3 days. You can already see where this is going. Here's the detail that rarely makes it into the pop history version. These ordeals were controlled almost entirely by the clergy, and there's decent historical evidence that priests could and did rig the outcome, using lukewarm water instead of boiling, or timing the iron so it barely touched skin, especially for people the church wanted to protect, or against people the community had already decided were guilty. The ordeal wasn't really testing divine judgment. It was outsourcing a decision the community had already made and dressing it up as God's will so nobody had to take the blame. And if you think trial by fire sounds bad, wait until you hear the ordeal that basically turned the courtroom into a duel. Trial by combat is exactly what it sounds like. Two parties in a legal dispute fight, and whoever wins is legally, officially correct. Not probably right, correct, the verdict. This wasn't a fringe practice, it was formal law across medieval Europe, particularly in Germanic and Frankish legal codes, and it survived in England well into the medieval period. If you accused someone of a crime and they denied it, and there were no witnesses, the dispute could be settled with weapons on a marked-out field under official supervision. Here's the part that's almost funny. If you were too old, too young, disabled, or a woman, you were allowed to hire a professional champion to fight in your place. Yes, professional judicial duelists existed as a job. Imagine explaining that career choice at a dinner party. I resolve property disputes with a sword for money. And the losing side wasn't just wrong, they were often executed on the spot, on the theory that losing a trial by combat proved God had judged you a liar, so you'd earn the death penalty for perjury on top of whatever you were originally accused of. Losing the fight was worse than losing the argument. The last recorded judicial duel in England was formally requested in 1818. A man named Abraham Thornton demanded trial by combat to avoid a murder charge, and because the law technically still allowed it, Parliament had to scramble to abolish trial by combat outright the following year, just to close the loophole. Trial by combat wasn't officially removed from English law by some grand Enlightenment decision. It was removed because one guy found the cheat code. So ordeals and combat get all the attention, but there was a quieter, less bloody method that was actually the most commonly used system in early medieval law. And it relied entirely on your friends. This is called Compurgation, or oath-helping, and it was the default method of proving innocence across Anglo-Saxon England and much of early Germanic law, far more common than ordeals or combat, even though it gets far less attention today. Here's how it worked. If you were accused of something, you didn't need physical evidence. You needed to swear an oath of innocence, and then get a specific number of other people, usually free men of good standing in the community, to swear alongside you that they believed your oath was true. Depending on the severity of the crime and your social rank, you might need 6 oath helpers. You might need 36. Crucially, the oath helpers weren't testifying that they saw what happened. They were vouching for your character and credibility. This was a system built entirely on reputation, which meant if you were well-liked and well-connected, you could talk your way out of almost anything, and if you were an outsider, a stranger, or already disliked, good luck finding 36 people willing to stake their own oath on your honesty. This is, structurally, the ancient version of a character reference, except your freedom depended on it, and lying under this kind of oath was considered a sin serious enough to damn your own soul, which was supposed to keep people honest. It mostly worked. Mostly. Now, Europe didn't invent any of this. Some of the oldest and strangest ordeal systems on record come from Mesopotamia, and one of them is baked directly into the most famous law code in human history. The Code of Hammurabi, written around 1754 BCE, is often taught as this landmark achievement of organized justice. An eye for an eye, proportional punishment, all very rational sounding. What gets left out of the textbook version is Law 2, which reads roughly, "If a man accuses another of sorcery and cannot prove it, the accused shall go to the river and throw himself in. If the river takes him, the accuser gets his house. If the river proves him innocent and he survives, the accuser is put to death instead, and the accused gets the accuser's house." Read that again. This is one of the very first written legal codes in human civilization, carved in stone, displayed publicly, and Clause 2 is, "Throw the accused in a river and see if he drowns." The Euphrates was, quite literally, functioning as judge and jury. Historians generally believe this worked slightly better in practice than it sounds, because rivers with strong currents could plausibly be survived by a strong swimmer, and there's speculation that, much like the European ordeals, local officials had informal ways of influencing who got the gentle stretch of river and who got the current that pulled you under. Once again, the myth is, we let God decide. The reality is usually, someone with power decided in advance and arranged the ordeal to match. Mesopotamia used a river. Ancient India used something you'd never guess, dry rice. In ancient India, one of the documented ordeal methods was the rice ordeal. The accused was made to chew a handful of dry, uncooked rice and then spit it out. If the rice came out dry, coated in your own dry saliva, you were guilty. If it came out relatively moist, you were innocent. Here's the part that makes this genuinely fascinating instead of just absurd. This test accidentally worked, at a rate far better than random chance. Extreme fear and stress physically suppress saliva production. It's the same reason your mouth goes dry before a job interview or a first date. A guilty person, terrified of being caught, would produce measurably less saliva than someone confident in their innocence. Without any understanding of physiology, ancient Indian legal tradition had accidentally built something resembling a crude polygraph test, powered entirely by the biology of fear. China had its own version using dry rice powder placed in the accused's mouth, evaluated the same way alongside other methods recorded in different periods and regions, including ordeals involving boiling oil, where the accused had to retrieve an object from a vat of hot oil, evaluated similarly to Europe's boiling water test. Meanwhile, in parts of West Africa, colonial and pre-colonial records describe the poison ordeal, sometimes called sassy wood or by other regional names. The accused was made to drink a preparation from a poisonous bark. If they vomited it back up, they survived and were declared innocent. If they didn't, the poison itself was considered to have delivered the verdict. Dosage, preparation strength, and who administered it all quietly determined the real outcome. Meaning, once again, actual human judgment was hiding behind what looked like a purely supernatural test. Notice the pattern repeating across 3 unrelated continents that had zero contact with each other: water, fire, poison, rice. Wildly different cultures independently arriving at the same basic idea. Outsource the terrifying responsibility of judging guilt to something that looks unbiased, even when it quietly wasn't. So, if it all secretly ran on human bias anyway, why did ordeals eventually disappear? The answer involves one very unimpressed pope. For centuries, trial by ordeal in Europe required a priest to bless the water, heat the iron, and formally invoke God's judgment. The entire system needed the church's cooperation to have any legal or spiritual weight. That ended in 1215 at the Fourth Lateran Council, when the Catholic Church formally banned clergy from participating in trials by ordeal. Without a priest to perform the ritual, the entire legal mechanism collapsed almost overnight across Catholic Europe. It's a genuinely underrated turning point in legal history. One committee decision in Rome effectively forced every court in Western Christendom to invent a replacement system within a generation. That replacement was trial by jury, ordinary people evaluating testimony and evidence and reaching a verdict through reasoning instead of waiting to see if you floated. It feels like an obvious upgrade in hindsight, but it was genuinely radical at the time. The idea that guilt should be determined by human judgment of evidence, not a ritual appeal to the divine. Trial by combat lingered on the books far longer than ordeals did, precisely because it didn't need a priest, just two willing participants and a sword, which is exactly why it took a 19th century loophole hunter like Abraham Thornton to finally force it off the books for good. Compurgation, the oath helper system, faded more gradually replaced by the same jury-based reasoning, actual witnesses, actual testimony, actual argument, rather than a head count of who was willing to vouch for your character. And here's the uncomfortable twist to end on. We like to tell ourselves that modern forensic justice, fingerprints, DNA, security footage, is a completely different universe from dunking someone in a river. And in terms of tools, sure, it obviously is. But the underlying instinct hasn't changed nearly as much as we'd like to believe. Every ordeal system in this video was, at its core, an attempt to find something, anything, that looked objective enough to hide behind, so that no single human had to shoulder the terrifying weight of saying, "I believe this person is guilty," using nothing but their own judgment. Water, fire, rice, poison, a sword fight, different tools, same underlying panic, the fear of getting it wrong, dressed up as certainty. Modern forensic science is dramatically more reliable than a floating body or a dry mouthful of rice. But wrongful convictions built on confidently presented, later debunked forensic techniques are still a documented, ongoing problem in courts today. We've just replaced the priest blessing the water with an expert witness in a lab coat, and both, historically, have occasionally been wrong with total confidence. So the next time guilty or innocent gets decided in under an hour on a true crime show, remember, for most of human history, that decision came down to whether your hand blistered in 3 days, whether you could outswim a river current, or whether 36 of your neighbors liked you enough to swear an oath on your behalf. We'd like to think we've moved on from letting fear and performance stand in for real proof. Mostly, we have. Mostly. Next time, we're going somewhere even darker. How ancient armies actually dealt with mass casualties they couldn't bury in time. The plague pits, the battlefield decomposition, and the diseases that spread faster than the fighting did. Subscribe so you don't miss it.
Make sure to subscribe for more epic content. And click that bell icon too.